thank you all for joining us. To level set, we're going to be talking about data brokers, which are typically defined as companies that don't have a direct relationship with consumers. These data brokers amass massive amounts of data on people, build profiles and dossiers that can be used for all sorts of purposes, including targeted advertising, which I know our next panel will discuss. With people seemingly more concerned about privacy and who has their data than any time in history, this seemed like a great time to talk about the future of the data broker industry and potential regulation of the industry. And with that, I'd like the panelists to just briefly introduce themselves and explain who they are, and then we'll dive into some questions.
Down the line here. Sure. Thank you. And thank you, everyone, for being here and for the invitation. So, Justin Sherman, I run a DC research and advisory firm. I teach at Georgetown. I work with Epic and some of the great groups here in DC. I ran a research program at Duke for a number of years on the data broker industry, and have worked as well government side on PADFA, which we'll get into, and the DOJ program on data brokers and a variety of others.
Hi, I'm Sarah Gagan, she/her. I am Senior Counsel at the Electronic Privacy Information Center, which is an independent research and advocacy center based here in DC. I personally focus on commercial surveillance, specifically as it intersects with health and repro privacy. And yeah, I work on a lot of commercial surveillance things more broadly, like online behavioral advertising and data brokers. So I'm really happy to be here today. Thanks.
Hi, I'm Susan Duarte. I work at the Comlaw Group, a law firm where I represent lots of different clients on marketing, AI, and privacy issues. I worked in the tech industry for most of my career. I'm just really excited to talk about these issues today.
Great. Well, thank you all. To start, Justin, let's start with you. So it seems like I can't read any articles these days in any paper without you being cited, raising concerns about data brokers. Love to get your thoughts on the most common and surprising methods that data brokers are using to collect consumer data. We start there.
Yeah, I'll say a few. So, one, which has been the case for decades, but we're still seeing is a tremendous amount of public records scraping and digitization and aggregation. And I just mentioned this because this is interesting because we're dealing with information that in some ways has been already provided publicly or deemed in some ways to be public, but still can create privacy and particularly safety risks, as we've seen for decades, to primarily women in a stalking and gendered violence context. We're seeing this now with both Democrats and Republicans and threats to government workers, members of Congress, and so on. So some interesting things there at a more basic level of ways that data is collected. I'll make 2 points about more unexpected. So one is in the mobile app space. For many years, particularly location data sellers would set up contractual relationships with app developers to provide GPS data and other location data to them through SDKs, through software development kits. So use this shell of code, put it in your app. Through that, we can facilitate access to user data at different levels of granularity, depending on the case, at different levels of frequency. Some of that's intermittent, continuous, and so on. But through that SDK, we've really seen a huge shift in that space in the last few years, where rather than using SDKs, and in part because of the SDK transparency efforts that Apple and Google have undertaken, which we can get into that too, but there's a switch to server-to-server transfers. So basically more obscure ways of getting access to the data. You're the app developer, you collect it on your users. Once it's on your own systems, you can direct transfer to us. And the third thing I'll just briefly mention, and I'll let if others want to weigh in, but is inference, which is nothing new, right? And I don't mean inference in the AI context necessarily, but derivation, right, of some information from other information, right? Whether that's taking a zip code and using that plus a name to make some problematic or not, or accurate or not, inference about race and ethnicity, to what we're seeing now, which is more sophisticated, such as if I have your location pings, perhaps we can derive things like, did you go to a gay bar? Did you go to a particular medical clinic? And as we'll talk about, there's national security cases. Did you visit a military base? So all to say, not every company is doing all of those things and so on, but those are some of the more surprising for policymaker practices in the market.
Sarah, anything you want to share on things that you find surprising or perceived to be particularly problematic ways that data is collected and shared?
Yeah, I think it's all harmful because we don't have a relationship with data brokers. We don't know that this collection is happening, and we don't agree to enter into a relationship with a data broker. Justin mentioned the inferences that can happen through this vast set of data that's out there about us, and I think some of the most sensitive categories of that can be location information or information that reveals sexuality or sexual preferences, political affiliation or union affiliation. It's really dangerous when domestic violence survivors' location information is accessible, political figures or public figures' location information, information that reveals pregnancy status, abortion care, or gender-affirming care. And when we're talking about specific populations of people, we know that this can be very dangerous, like immigrants, public figures, people like that.
Susan, I want to ask you, as someone who represents companies in this space or that have to comply with laws, is there like a sliding scale of badness, like things that companies shouldn't do, or things that are less bad than other things?
Yeah, I mean, I think Sarah just touched on sort of the highly problematic. I think it's a hierarchy, probably. Just all of the things that she mentioned, we're seeing enforcement in those areas, especially anything that seems to be touching or causing consumer harm for children. I think moderately is just when you're saying things that you're collecting things and then you're doing other things with it. And then probably just there's a less concern with other types of data uses that people would come to naturally anticipate. I think another big thing is security of the data, and really making sure, and I know other panelists will touch on that, making sure that it's not open to breach and things like that that can actually cause direct harm.
The one thing I want to ask is seems to be some tension, right, between the value of the data is really this precise geolocation inference data that you can collect, and that data raises a number of concerns about being in, like, having companies having that data in their possession. So without consent, what's the best mechanism for these data brokers to get consent, or how does this practice stop if they're not getting consent?
Is it to me?
To
Or
you.
anyone? Before I answer that, I do want to add to something Susan was just saying, which is we should also say, right, I mean, we're talking about, in this generally, I assume, right, data brokers that are collecting personal data. Mm-hmm. There are also data brokers that don't collect personal data, and I don't mean data that's anonymized to some superficial degree where you can re-identify easily. I mean literally companies that sell like weather data to the DoD. So just to say, right, there are also companies out there that are quite afield from what we're talking about. Commercial satellite imagery is a different question, let's say, but there are things like weather data that are sold. That's quite different than what we're saying. I mean, consent, again, I think, I'm sure I unfortunately could not make the earlier sessions. I'm sure I'm echoing prior panelists and saying, right, I think our notice and choice model is quite broken. And, in my opinion, broadly, are there companies that, responsibly collect and handle data, do it with a degree of consumer understanding, do it where the consumer has a reasonable expectation about how the data is collected, what will be collected, how it's used? Yes, absolutely. Right? Is that something that's going on when you're a third party that's so removed from someone they don't know who you are, or you're a first party, that, as has happened with Life360 or BetterHelp or others, where would a consumer have a reasonable expectation that a family safety app is reportedly selling kids' location data? Well, probably not, right? So even if there is that first party relationship, you have instances where the practices are so far removed from a consumer expectation that, and then I can go into the whole thing about privacy policies, but it's so far removed from expectation that I don't really think so. I'll let my colleagues add.
Yeah, I agree. I think the consent system is broken and just fails to provide actual protections for consumers, especially when we're talking about consumers that don't have this expectation of this data collection or processing because they do not have a relationship with the company. Right. So I think there's no substitution for substantive limits on this sharing of information.
Well, so Susan, I mean, let me ask you, is there a mechanism by which adequate disclosures could be made to provide enough notice, or what would that look like?
I mean, I think, and here's a standard lawyer answer, it depends. I think, I think being transparent with your customers is good for business, just sort of level set. And then just having very clear disclosures along the sign-up path or when information is shared or if you're using an app. Don't just say everything should be buried in the terms and conditions. I mean, it's definitely always a push-pull between legal and the business because they obviously just want to push everything to that document. But I do think, the more transparent you are, the less likely you'll have complaints or investigations because you'll be upfront and people know what they're getting into. I mean, I think basically humanity just doesn't like it when, people are liars or things like that. So, yeah.
Yeah. Okay. I think with all these concerns, why don't we move on to talking about and exploring what enforcement and regulation of this industry is going to look like going forward. I think it's probably fair to assume that under Trump 2.0, we're going to have more of a light touch regulation probably at the federal level, has already been evidenced by some of the things that have been happening. So it seems like regulation will be up to the states here. And what do you think about like a patchwork or a non-uniform number of different states enacting laws? How's that going to work from a consumer protection standpoint? Sarah, if you want to start.
Yeah, light touch is a euphemistic way to put this administration's approach to consumer protection. This administration has slashed regulation to protect consumers across the board. It has initiated a federal data demand to collect and aggregate data at an unprecedented level. It's completely gutted the Consumer Financial Protection Bureau. It's fired bipartisan leaders at the Federal Trade Commission. It's directed its agencies to protect consumers less. So I do think we find ourselves in a scenario where states will be filling in the gap, which is not entirely new because of the lack of privacy legislation on a federal level for years and years. I don't think this means that there is zero chance to move consumer protection forward at the federal level. I think we'll talk about PADFA in a bit, but the FTC has authority to enforce the Protecting Americans' Data from Foreign Adversaries Act, and commissioners have recently expressed intention to do so. And I think that's worth its own discussion. We'll talk about it in a minute. But it's worth mentioning. And so, yes, I definitely think that states are going to step up. They have with consumer privacy laws in general. Attorneys general across the country have been initiating lawsuits and enforcement actions to protect consumers' privacy. And yeah, I think that if industry is upset that there is a confusing, chaotic patchwork of laws, they played a hand in having a lack of federal protections. So it is not ideal, but this is where we're at.
And Susan, given that, again, since you represent companies that are trying to navigate these laws, what's the path, what is like the course of action for a company? Do they comply with the strictest state law, or do they have individual policies for different states? What's the best course of action?
Yeah, I mean, again, I think you have to tailor it for your business and your business needs. Some of the smaller clients, they just can't have all the strictest requirements in place, so they may want to try to geofence or do other things that they can just comply in certain areas. Then you see that other companies are very compliant and they want to implement all the strictest practices. Again, I think it comes down to what makes sense for the business, especially risk tolerance and things like that.
And Justin, do you want to talk about some of the national security related issues that could be policed at the federal level, transferring data to foreign countries, potentially geolocation data about our troops being released and things like that? I think you're testifying in front of Congress next week about some of these issues.
Yeah, practicing here, I guess. So anyone wants to lob political questions at me, practice. No, I mean, just as Scene said, right? So it goes without saying, we're all here, we all work in this area, but, we've really have had a real explosion in the amount of data around the world available on people, digital device connectivity. And I teach open source intelligence and national security law at Georgetown, and this is a relevant area on the flip side, right? There are lots of ways that the data and digital environment has advantaged the U.S. and its allies in military and intelligence and cyber operations. This also creates risks, though, and this is relates to what we're talking about, which includes that You can either take a comparative approach, which is the way other countries have perhaps locked down their data ecosystems more in the United States. If we're interested, I can list outbound data restrictions in China, for example, that are really interesting. But even apart from the comparative point, you have a tremendous, as we're saying, amount of commercial data available in the United States, both from data brokers as well as through real-time bidding, ad exchanges, through all kinds of other systems. And so the question becomes, is there a national security risk that a foreign adversary could potentially get access to different parts of the data that would do different things? Maybe it's cheaper than hacking it. Maybe it provides insights into something a government agency would not have on file. Like, could you get 24/7 geolocation signals of U.S. troops on some, Navy server? No, right? But could you get that from a data broker potentially, right? So all to say, and this is not just me saying this, right? In the last couple administrations, and a lot of this was catalyzed actually under Trump 1.0, a lot of concern about the degree to which China was hacking and stealing Marriott, Equifax, data broker, right? A lot of companies and amassing all of this data. Well, what are the risks that they could combine it, apply analytics and machine learning and other things to it, and use that against U.S. interests, build profiles on intelligence officers and the like. So all to say, this has been going on for years, but started as a concern there. In the last administration, we had an executive order to set up a DOJ, with which many of you are undoubtedly familiar, perhaps working on compliance for, a bulk data transfer program. I was the U.S. government's SME consultant on that program, so happy to talk more about it. But that set up something looking at that concern of, okay, can we try and limit the amount of data that might potentially... We're not touching a bunch of the other stuff, but we're just going to look at the China, Russia, Iran, mainly China, but North Korea. I'm not sure how much data North Korea is buying, but, really focused on China. And then concomitantly, and this was very not ideal, and I've written at length criticizing it in some ways, but there was the PADFA, as we've referenced, the Protecting Americans' Data from Foreign Adversaries Act. I worked on an earlier version of this. I do not really like the ultimate version they passed, but it's now in law, and this was basically attached to the TikTok ban or divest law, which basically came out of them saying, well, what about we're banning TikTok? Well, what about if someone could walk in the front door and buy it from a company? And so all to say, now you have a program at DOJ that's still there that has compliance requirements for companies. If anyone works on CFIUS or other things, it's similar reporting structure to foreign investment reviews and other things. And then now the FTC also has an authority to go after, and I can break down what they are, but people can look that up, to go after data brokers there. So that was a bit rambly, but basically you have these two programs, and the concern is the national security risk. And I'll just say one last thing, which is, in addition to being under national security authorities, which is why neither of those were about privacy per se, there's also an important point, which is the same in other areas, which is the controls you might put in place to prevent a criminal hacker are not going to be sufficient against a nation state, right? And this is not specific to data brokers. This is true of if you're selling weapons, if you're working in biological and genetic disease research. Like, this is true in lots of areas. The companies have what's the threshold of practices for most bad actors, and then what's the, and it's not your fault if you get hacked necessarily all the time, but, what's the threshold for a nation state? And I think that's similar with this.
So just for example, we worked on a company where one of their data sets that you could use to target a particular class of people was people that have been or likely been on military bases recently. Mm-hmm. What sort of, outside of being able to target them, presumably you could use other information or glean other information from that data set. Wouldn't that, why is that still out there and available to the general public to consume, or I guess to commercial entities to consume that data and information?
Well, it's a good question. Under these two programs, right, they're focused on sale to foreign actors under different circumstances. There's bulk threshold, there's thresholds and data type requirements and stuff. So it doesn't mean don't sell anything on service members to anyone at all. There's parameters around who would you sell that to, and so on. And like we're saying, not everything is going to be useful in the same way to a foreign actor. Like, again, things one might not think are useful are in fact sometimes useful, but the extreme end would be something like Wired did an investigation I worked on with them last year of a European data broker that sold geolocation pings showing active duty U.S. service members going from Ramstein Air Force Base in Germany to brothels at night and then coming back on base. Like, that is something that is a tremendous concern, not just from a privacy standpoint, but from a counterintelligence perspective.
And Sarah, maybe this one's for you. And one of the things that this administration has signaled that it likes to do is crack down on its opposition. And so, this data and the data sets that we've seen can give you indications of which party people are likely to vote for, other groups that they may be organized or associated with, potentially like immigration-related issues. With the potential to weaponize that data at the federal level, I mean, does that cut against any strong potential, any real regulation by the FTC or the DOJ or anything like that, or any enforcement for certain types of things?
I think that shows why we need stronger prohibitions on the collection and sharing of this information to begin with. These dossiers about people have existed for years and years, and ICE and DHS, for example, have used information from data brokers to surveil and deport immigrants for years. There is now a new scale to this, led by the federal government, but I think the weaponizing of opposition to current political leadership shows exactly why having these dossiers that exist and are out there and are so easily accessible by any actor is just evidence that we shouldn't have these dossiers out there in the first place.
Yeah. Let's move on and let's talk about specific states and the regulators or the agencies that exist in those states. I think the CPPA in California is, as far as I know, the primary state-level privacy regulator. Sarah, I know you have some thoughts on maybe where they're succeeding or they're failing or what they do better. I don't know if you have thoughts on that.
Yeah. Well, I'd like to say that the Maryland Online Data Privacy Act goes into effect today, but California is the only state that has a dedicated privacy agency, which is important because that was decided by voters in California, and then this dedicated agency has specific expertise and knowledge about data privacy issues that typically legislators and governors or other leaders just don't have. So it's a specialized agency, and it's led generally in consumer privacy in a lot of ways for years. It did pass a pretty big comprehensive law, and it has spent a few years promulgating regulations to implement and clarify the law. Very disappointingly and frustrating to watch in real time, its most recent set of regulations regulating automated decision-making technologies, cybersecurity, and risk assessments was watered down pretty substantially at the behest of big tech, aided by the governor, and it narrowed the definition of what an automated decision-making technology is, so it became, it applied to fewer technologies. It watered down some of the cybersecurity obligations, and it completely omitted some of the risk assessment requirements that would have provided some transparency to the agency about how companies in California are using technologies to make consequential decisions about Californians. That's not to say California is completely moving backwards. I think that there's been some pretty promising ideas about enforcement, and again, this state has a dedicated agency for privacy, so it has a pretty strong enforcement arm. The Deputy Director of Enforcement, Michael Macco, recently said that they're getting like 150 consumer complaints a week under the CPPA, and they are taking action. Just an enforcement that was announced yesterday against a very large retailer included in the provisions privacy protections for job applicants and employees, which sometimes are carved out of other privacy laws. So there is definitely some promise and hope for enforcement actions in California going forward.
And one of the big things that I think industry is concerned about, or there are concerns amongst the data broker industry, is the new drop system that's going to go into effect in California. I don't know if, Susan, you want to explain how that's going to work, and then maybe we can get everyone's thoughts on how effective that might be. But
Yeah, sure, and others can add to it. But I believe it's 2026, if memory serves correct, that they will have a mechanism where consumers can put in information that they want to be have their data deleted, and that companies every 45 days have to go in and check it and scrub against the list. So I think you'll probably see an uptick in enforcement after that occurs.
do you have any thoughts, Justin, on how effective this might be in terms of limiting the supply that the data brokers rely on, like the information about consumers that the data brokers necessarily need?
Yeah, I mean, obviously we have to see what the system looks like. You've asked Consultani, who was there for a period of time, and a number of others in this area who are very sharp and have a lot of experience building these technology systems in enforcement agencies. So we'll see. But as a general point, it's much like telling a consumer that they read every privacy policy they see is like literally not viable. And if you don't believe me, go read the 2008 paper that Lori Craner and others did. With how long it would take at the time and how much cost in working hours to the U.S. GDP it would cost at the time if everyone did that, and that was in 2008. And so, anyway, but much like that's not viable, it's also not realistic to say to a consumer, here's this registry, like in Vermont or Oregon or whatever, well, 4 states, Vermont, Oregon, Texas, California, that has 500-600 entries, go click on each one individually, and like no one's doing that, right? So having a one-stop, whatever the underlying rights are, and I agree with what Sarah said in that area, having a one-stop shop is essential for actually effectuating those rights. And again, maybe there's a mechanism if for some reason a consumer didn't want to opt out from all of them and there were some they were fine with or something, okay. But it's good to have a one-stop free system. Right now, we in some ways need these privacy tech companies for deletion and things, but in an ideal world, in my opinion, they don't even exist, right? This is there's not this cottage industry. It's rather, it's free for consumers to, it's not a controversy, free for consumers to exercise their rights rather than paying for it.
Right. One thing I want to talk about is, California has been particularly active in these enforcement sweeps. There's been settlement with Honda, Todd Snyder, Tractor Supply Company yesterday. One thing that I think people are always concerned about is like whether these fines are just the cost of doing business or there's actually meaningful change that's being implemented. And I'd love to get your thoughts on that, Susan, as someone that might help companies navigate the risks from California.
Yeah, I mean, I think that smaller companies, those fines are large. For the larger companies, it could possibly be that it's worth the risk. I mean, I think just to level set, companies have customers so they can sell their products and services, and some of the information they're getting is to make that a good customer experience. Not everything is used in a nefarious or bad way. And so I think it's important for them to just make sure that they're being very transparent and things like that we've already touched on. So, it is definitely worth discussing the risks. And yes, sometimes things just go too far. I mean, we're wearing our rings today, and that information, who knows how they're using that information, so.
Right. Do you have
No.
You're worried about
I don't have one of those, but I don't have one of those, but I take the point.
So there was a UC Irvine study that came out from this summer that found that 43% of the registered data brokers in California weren't responding to data access requests. And so what good, I guess, are these data rights if non-compliance is so widespread? I know they're going to increase fines, but is that going to be enough for more data brokers to fall in line, or is it the case where the bigger companies can just pay the fine and move on, and smaller companies go out of business, or is that going to change with some of these new things that are going into effect?
I think education is also an issue. I see many companies are not sure. I mean, it's obvious if you're a data broker. Sometimes it's not as obvious. I mean, T-Mobile's on the list, Marriott, large companies that wouldn't necessarily think of as in the category of data broker. So I think maybe you'll see companies trying to get a better handle on that. But yeah, I definitely think that one of the strong messages is enforcement, and that's how companies change behavior, especially if they're hoping to not get the fine. They may just make the change in advance to be proactive and try to settle quietly.
Mm-hmm. I think Ethan wrote a story for us a couple days ago about how California has 100 active investigations. And they said they haven't surfaced in a few of them, but in terms of potential, non-compliance with some of the laws that exist in California, what areas do you think California should be prioritizing to try and set precedents and try and make companies comply? And we can start with Justin and then Sarah, if you have thoughts.
Yeah, I mean, we're talking a lot about California, which is great. I'll also say Texas has been highly active in this area. Again, this is like a strongly bipartisan issue. Klobuchar and Cruz, of all people, just yet again paired up on a bill the other day in this area. But in California, I also editorialize as always. I want to make one point, which is just that it's sort of amusing to me. I mean, we can get into big tech lobbying, but that, lots of large and other technology companies and banks and advertisers and others for years have been building systems to comply with data subject access requests in the EU under GDPR, what have you. And yet the data brokers act as if, processing an opt-out is like, flying to the moon, on a tiny little plane, and like it's the representation is that this is this infeasible thing. But just to say, California, I mean, obviously they have thoughts. You mentioned active investigations. I understood the reasoning. I didn't agree with the decision, and I wasn't happy. A piece I wrote for Epic, I resubmitted a public records request to California to get more information about what are they looking into, and they had previously responded to that exact same verbiage a year earlier, and this time denied it. And I was very unhappy about that, as they know, but I understand the reasoning. And I also asked, by the way, about investigations into data deletion companies as well, and they also did not respond to that. But in terms of what should they prioritize, I think, like we're talking about, there's the question of incentivizing broader compliance. There's also a question of harm prevention, and those overlap, but those are not necessarily the same thing. So I would say cases that, and you can't go after people search websites for a complex set of reasons we can get into, but I would say if there is a company that is not complying in a way that puts survivors of stalking or gendered violence at risk, that puts public servants and their families at risk, election workers, what have you, from a harm prevention perspective, that would be my first priority. Right over like an invasive ad thing, which is also harmful, but is 1 degree removed from somebody trying to kill you. But in terms of, like I said, incentivizing, I realize those may not necessarily be the same thing, and so really blatant violations are good. I also think going after big players that make these specious arguments or perhaps don't have the right programs in place, but are trying, even if they're not compliant, are good ones to set the incentives in the right way.
Sarah, did you have any thoughts?
Yeah, I echo everything Justin is saying. I think the study that you just mentioned with the 43% of noncompliance shows that, I mean, that's egregious noncompliance, and it shows that self-policing of industry just won't work. We need enforcement, robust, that has teeth. And also echoing that Texas is doing some interesting things there. The AG is suing Life360 and Arity, which is a data broker, for secretly embedding the data broker's technology in Life360's apps and collecting information about people, and they had no idea. In terms of priority in California, I agree with the serious harms for people's safety and physical lives and well-being should be placed highly on their list. I also think out-of-context data uses should just be a priority. Things like online behavioral advertising. I think California standard has a pretty interesting data minimization standard, and they should go after some big fish that are using our data in ways that isn't really necessary for why it's collected in the first place.
Susan, did you have anything to add?
Yeah, I think we're seeing more and more enforcement of the opt-out signals. I think that is a priority. We're seeing it with even banding together with other states, California, Colorado, Connecticut, and then even the fine yesterday, they touched on that specific topic. I think the other big thing is if you say you're doing something, then you should be doing that, and you shouldn't be acting in ways that contradict what you're saying. And from what I understand, the regulators are actually reading the policies right now. They're actually sending emails to the contact us. They're checking companies to see, are your practices lining up with the policy? So I definitely think you're going to see more of that coming.
That's good. Okay. And yeah, I know you all want to talk about things outside of California, so let's do that. So I think there's 19 privacy bills now. States have their own comprehensive privacy bills or laws. I'd love to get your thoughts on what stands out to you, either positive or negative. I know there's a large focus on special protections for minors, which I think everyone is on board with. And Maryland has a new law with pretty robust requirements around what constitutes sensitive location data. But yeah, Sarah, if you have any thoughts on positive, negative trends, what states are doing good job, what states can go further, that we can start there.
Yes, it's a lot to keep up with the states because everyone does something different and they all do it in very different ways and have different timelines for their sessions. I think the Maryland Online Data Privacy Act, again, goes into effect today for any residents of Maryland who want to exercise their privacy rights, has pretty strong data minimization requirements and some good definitions for their sensitive categories of data. Unfortunately, some states' laws have kind of been written by Amazon and big tech, so it really depends a lot on the state. Some states have some really interesting proposals, and then big tech gets involved during the process, and the final result is watered down. But some states have passed, bans on the sale of geolocation information, special protections for things like abortion care. So it's kind of a mixed bag, and it's a lot to keep up with. But there's definitely some interesting protections that are coming out from the states.
And on this notion of banning precise geolocation data, Justin, I know Oregon has banned the sale, I believe. Do you know if any other states are planning to follow suit or?
Planning, I don't know. I know we have a lot of lawyers here. I don't envy you and having to track every which one of these ridiculous versions of bills. I mean, it's come up in Massachusetts. It's come up in other states for a variety of reasons, including around kids. But what's the appetite? I don't know. Sarah and Susan would have a better sense. I was involved with Massachusetts, and that sort of fell away as an example of something, right? People move on, and it's just it doesn't hold as long as a priority. So
I don't know, Susan, do you have any thoughts on that?
No, not on
Okay.
that.
And then one of the, typically when we see a light touch at the federal level and sometimes at the state level, and I think some states are overwhelmed, we see a rise in private litigation. And I think there's been a number of suits, Life 360 has been sued on the level by private plaintiffs. A number of other data brokers have been sued, and a lot of the allegations are usually like, I had no idea you had my data, which makes sense. Are you seeing, Susan, more private litigation? Do you think there's maybe an appetite? I know some of the state laws don't have a private right of action for violating some of the state laws. Do you think that might change, or are lawyers being creative in ways to kind of overcome the lack of a private right of action that's carved out under state law?
I mean, I think for plaintiffs' lawyers, where there's a will, there's a way. So even under the CCPA, they've been stretching the security breach to use it sort of for ad tech issues. And we've seen an increase in litigation from about 1,500 privacy cases to 2,500 in 1 year. It's definitely dramatically going up. The California Invasion of Privacy Act is another big one. That's the wiretapping law where they're saying if you're collecting cookie information or sharing it with tech or things like that without consent and notice, that is a violation of the wiretapping. Platforms who are just collecting, or their sort of AI type platforms may be accused of eavesdropping under these laws if there's no consent that there's a note taker or something is there. So I definitely see an uptick there. Another one that's really big and top priority is the BIPA claims in Illinois. So we're seeing a lot of the biometric litigation. I think the big reason you see a lot of SEPA and BIPA, I'm not sure if I'm saying them right, is because it's $5,000 per violation, so the liability could rack up pretty quickly.
And then one of the sort of tensions that we see with the state laws is they seem to have a carve out for data that's collected for credit reporting purposes or things like that. You want to talk about that, Justin? Why that exists, and what the potential problems associated with those carve outs are?
Yeah, and then I'll opine briefly on something you didn't ask about, which is the publicly available information carve-outs in state privacy laws. But yeah, I mean, it's the underlying reason is completely sensible, which is, okay, we're writing a state privacy law. Where might this potentially touch a federal privacy law, and how do we not start overlap? And federal bills do this, right? Federal bills that similarly will just copy paste as offices write these. Will not overlap with HIPAA, will not overlap with GLB. It's the same list, literally sometimes copied and pasted. And so with state laws, yes, you have carve-outs, for example, for FCRA, the Fair Credit Reporting Act, for consumer reporting agencies, CRAs under FCRA. And same with Gramm-Leach-Bliley Act, right? And the way financial institutions and others under that act handle credit and consumer-related information. So all to say, again, I understand why those are written in there. There's lots of reasons to have those in there. Something that Caroline, one of our colleagues at Epic, and I did in a recent paper was just look at what kind of gaps does that create in terms of data broker coverage, ways that can enable circumvention of different rights or claimed circumvention, claimed ability to not provide certain rights. To include the stupidest one that you see constantly is people search websites that will sell data to a landlord or to something clearly covered under FICRA, and then put at the bottom of their website, which who's reading the bottom of any website ever? Other plaintiffs, lawyers, and regulators. No one else, and the lawyers who write it. No one else reads it ever, and then it just sits there. They put on the bottom, "Oh, do not sell to a landlord, and you agree you won't, and we're not covered under FICRA." It's like, well, unfortunately, that's not how the law works. That we can't just say, "Oh, I'm not covered." So anyway, that's sort of the short version of that paper. The second thing I'll just say is all of these state privacy, consumer privacy laws that are passed have almost, or in some cases verbatim, the same carve out for public records and publicly available information. And this creates a problem, like I was mentioning, because a lot of the again, I'm just going to say this again because this has been going on for 30 years and gotten so little attention, is the stalking and the gendered violence. And again, now threats to, we're going to sit here all day, I could list out detectives in New Jersey working gang cases who people show up to their house when their kids are home with guns because they bought it off a People Search site. Federal worker, like crazy things. Judges, the pizza deliveries to judges, like I can go on, I'm getting annoyed. But like there's a lot of that comes from public records. And so when that's carved out wholesale, you have things like in California, if you want to delete your own data, won't matter if it's from a public record and it's a People Search site. Under the law, the company might choose to do it, but under the law, you can't do anything. That's replicated across all the states. So my TLDR on that, as I've written, is I understand there's lots of complex First Amendment questions around public records, around their accessibility, around elections oversight, around, hey, Congressman, where's this fourth property you just bought coming from? All the things that happen, right, that people want to look into, journalism. At the same time, though, we have a weird binary where you have, and I'll put myself in the privacy advocate bucket, right? You have privacy advocates who say, take it all down. No one wants to see any of this data ever. And it's like, well, it's a public record. And then some ACLU and others who say, don't touch anything. It's out there anyway, and people are getting killed. So my point is, like, I think we can take a more middle ground approach that, now I'm in a rabbit hole, but that we avoid when we have these, again, we're talking about copying, pasting, like copy, paste, carve outs for public records, which includes letting a lot of these data brokers and the FICRA-covered data brokers off the hook.
Okay. Sarah, did you have something you wanted to add? I don't know if there's...
Maybe, but not at this moment.
Okay.
I forgot.
So I'll do closing remarks, and then we can ask if there's any audience questions. So I guess generally, just like, well, I guess before we do closing remarks, just for our purposes, are there any lawsuits that are pending or anything that's moving that you think is like really important or could be precedential that could have an impact on the industry that we should be paying attention to?
I think some of the Doge litigation is super interesting. I am biased because I am participating in some of it, but I think it is showing how federal data demands are scary and can be harmful to so many different types of people, and I think we should be keeping an eye on this. I think some of the Texas AG lawsuits are very interesting. I think some of the attorneys general lawsuits that are mirroring some of the Doge litigation is really interesting to see because we talked about state enforcement. We have some really eager AGs that want to protect the people that live in their states. So I think there's a bunch happening right now, and it's good to keep an eye on.
Susan, did you have?
No, I
Okay.
agree with that. All that.
Okay.
Yeah.
Anything that stands out to you, Justin? Or
No, everything mentioned, consent decrees that the FTC has actively with certain data brokers, as Ethan has reported, and others. There are obviously we don't know, but there are open questions in some cases about the enforcement and what's going on there, compliance with those active orders.
And I will say they are enforcing, and they are. This week was a big week for them at the FTC. They seem to be very focused on things that cause consumer harm. So I don't know if they just haven't gotten to these areas yet. They seem to have been focused on some other consumer harms this week. So maybe we'll see more coming from the FTC.
And yeah, I guess so. I mean, that's sort of my closing question. Is just like all these things that are happening seem to be working against the data broker industry potentially. Obviously, the people that work in this industry and the lawyers that represent them are intelligent. how is this going to fundamentally reshape the data broker industry? Will we see a shift away from opaque data sharing towards more transparent consent-based systems, or are we not really going to see any meaningful change? I'd love to get everyone's thoughts on that.
Go ahead.
I think we will see some changes because of the current climate where people are not going to want all their information to be so exposed. And because of that, there's going to be a change in the market. That's the rosy side of things. I'm sure there's other ways that things can be shared without consumers knowing about it. But again, I always harken back to it's not good for business when you upset your customers.
With that, I agree entirely. Yeah, I mean, like we said, some of these things might shift incentives. California and Texas, huge states, huge markets, very active right now. Okay. The DOJ program I mentioned, right? Lots of companies are not going to be doing business, say, in China, where they are directly in the scope of the threat concern per se, but they still have to comply with that program, which includes know your customer requirements. Crazy concept, but a lot of companies don't do that. So know your customer, right? So there are things that I think will propagate through the industry, but broadly, I mean, for decades, I mean, you can go back and find speeches from the 60s and 70s where you have executives in this industry talking about basically if consumers know what we're doing, bye-bye industry. So, I sort of think that the fundamental incentive to conceal the data collection is, and again, while you have some companies that are very transparent in broader private sector generally that are very transparent about their data practices because they know the consumers expect them, or they are reasonable, or they have those protections. A lot of this is in the area where I think companies just do not have any interest in actual consent or transparency.
Sarah?
Yeah, people like privacy. People don't like to be surveilled. And so I do think we live in a world where people unfortunately have privacy resignation, which is a concept that you can't really control your information because of such harmful actors like data brokers. So we've kind of resigned to that. But I do think we are starting to imagine a world where this is no longer the case. And this truly is bipartisan. Gun owners don't want their information publicly available where anyone can buy that. People are uncomfortable with ICE having information to surveil their neighbors. Political leaders and public figures, these are really concerning issues, I think, really to the average person, in a way that because of the creepy and annoying practices that these surveillance companies have done to us for so many years, people are really just at a point where we prefer privacy. And I think that lends itself to, there's a lot of different mechanisms that I think this can happen through, but yeah, I think eventually we'll have more privacy protections for this information.
Yeah. Jake, do we have time for? Does anyone have any questions from the audience?
I just wanted to ask, in terms of harms, are you saying like with the location data, like blackmail and things like that? Have you come across instances of that?
Yes, a Catholic priest was blackmailed by an organization that outed him, and they bought his location information from a broker. So yeah, and that's what we know about. I mean, I think there's an element of blackmail where we wouldn't always know what's happening.
And I just, for 10 seconds, I'll be quick, I promise. Just because I worked on that post investigation, to be really, really double click on what Sarah said, this was a couple individuals who bought bulk geolocation data with ping, 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 ping. I mean, the photos, which they didn't release, which I get, were horrifying if you look at them. The dots of where people were going that they got from Grindr. But then that this group, these couple people were able, not a company, not the Chinese government, a couple people were able to use this themselves to winnow down, to track, identify, and out this person. So I think just to make the point also that we know that large, Meta could do that, a foreign agency could do that, but if individuals are now at the point where they can do that, I think that's really concerning.
We did an article a few years ago about how having these dossiers, shadow dossiers on people without their consent will require you to have, private investigator license to legally retain that type of information. Are these companies all violating your private investigator licensing laws and subject to potential criminal violation at the state level at all the states that have private licensing laws on the books? Private investigator licensing, I should say.
I am not entirely sure about that. I do know that generally, and this legislation that I'm sure Justin knows, we probably all know about, is a lot of times purchasing from data brokers is a loophole to things like that. For example, the Fourth Amendment is not for sale act would try to close that loophole because law enforcement can actually purchase this information even though it has legal obligations from the Fourth Amendment of the United States Constitution to have a warrant for obtaining such information. But when you can just buy it, it kind of bypasses that requirement. So I'm actually not sure about those specific laws. I don't know, but I do know there is other evidence of circumventing requirements like that for information. I don't know if you...
I'm not an expert on those. It strikes me as similar to the California Invasion of Privacy Act type things that you wouldn't anticipate that applying, but perhaps it does.
I think that's all. Thank you all very much.
We'll take a 5-minute break and come back.
Thank you.
Thank you.